Good afternoon. My name is Eric Garza. I'm the chair of the ADR section for the San Antonio Bar Association. We thank you for joining us today. We're very fortunate to have a couple of guest speakers to talk about mediation and capacity, an issue that has been much discussed over the last year or so by the ADR section. Before we get into our speakers, I'd like to touch base on a couple of housekeeping matters. First of all, stay tuned for more programming. We're going to have more programming around the corner here. Aside from this matter, and we're very sorry that we weren't able to have the speed dating event that Rob Eichelbaum had planned, along with some of the other members of the ADR section, and we're hoping to get that back on track perhaps next year. We have a couple of other programs slated for the rest of the year. Those that touch upon arbitration, those that touch upon family law mediation, others include early mediation, something called a new ADR process, and then even something different, non-traditional ADR, mini trials, moderated settlement conferences, and so forth. And so that's one thing. The other thing I wanted to mention is that we did make a donation in the name of Alan Dubois over this past month or so to two programs that were recommended by our good friend Tom Kaiser, and who was a close friend of Alan Dubois. We made donations in Alan's name to the San Antonio Council on Alcohol and Drug Awareness, as well as to Rise Recovery. And I wish to thank the San Antonio Bar Association staff, Ashley Benson, Patty Brown, our treasurer, and Jackie Nicodeme for their help with that. Aside from that, I want to make sure that the our ADR section is aware of programming that is still available. You can still register, and I will put a link in the chat for the ABA, the American Bar Association's dispute resolution section arbitration training that will be taking place June 1st through 3rd. It's in Chicago, but there are some discounts available to us, which I will put out there. And also we have upcoming the dispute resolution section's spring conference. That's slated for April 25th through 29th. It is virtual, so you don't need to travel anywhere. And also there will be discounts available on that. It should be a pretty good program, as I've attended a couple of those before. Now, back to our the highlight of our meeting today. We're very fortunate to have Carol Birch and Tony O'Brien with us today. Carol Birch, as many of you all already know and have met, she's an elder law attorney serving San Antonio and the surrounding communities. She received her JD from the University of Texas Law in 1992. And since opening her practice, Carol's been a champion of the elderly and disabled, even making house calls to those unable to get out so they can receive the full benefit of her legal counsel. First and foremost, she treats clients with dignity and respect they deserve, and is always appreciative of the wonderful tapestry woven by their life experiences. With patience and understanding, she helps her clients plan for the challenges of aging. And as our community in San Antonio, as we all know, is an aging community, her services and her expertise is, it has been no more clear than now. And she continues to serve as an excellent resource and just a great friend and person. And so we're very, very thrilled to have her here. She will introduce Tony O'Brien, and we will be discussing today mediation and capacity. So Carol, thank you very much for joining us, and Tony, please take it away.
Great, thank you, Eric. Hello, everyone, and thank you for having us present today. Let's see if I can get this to, there we go. Okay, so I am Carol Birch, as he said, and presenting with me is Tony O'Brien, who is a certified mediator in our office. Tony has been with me for about 4 years and has gained a lot of experience in dealing with folks with incapacity, because in an elder law office, as you can imagine, we see lots of diminished capacity, ranging everywhere from someone who's just been diagnosed with mild cognitive impairment to someone whose dementia is so severe that they cannot even hold a conversation. Capacity is a continuum. At some point, though, you reach incapacity. And at that point, it's not a matter of accommodating the disability, but a matter of recognizing that you can go no further. So I'll talk first about what to look out for in terms of evaluating for diminished capacity. And then Tony is going to apply that in the mediation context. And if you have any questions, please feel free to put them in the chat or the Q&A, and we'll go over them as we see them. So the capacity that we're talking about today is contractual capacity. And as most folks know, that's a higher standard than testamentary capacity. Can the party to the mediation understand the business being transacted and understand the nature and effects of her actions? Further, in the mediation context, can the person with diminished capacity understand the role of the mediator and the party's relationship to the mediator? But how do we know if a person has diminished capacity? There's no single marker that just tells us, oh, this is a person with diminished capacity. The mediator has to be alert to some red flags that indicate possible problems. And those red flags can present as cognitive signs, emotional signs, or behavioral signs. So, for example, possible cognitive signs of diminished capacity include short-term memory loss, communication problems, comprehension problems, lack of mental flexibility, calculation problems, and disorientation. A person with short-term memory loss may present well in initial conversation, but later is going to ask the same questions over and over, or will need information repeated because they just can't grasp it the first time. Communication problems could be evidenced by having trouble staying on topic when asked a direct question, or shifting to discussion of an unrelated issue. Repeated difficulty finding words is also an example of communication problems. Comprehension problems are indicated if the person has difficulty repeating back or paraphrasing simple concepts. Mental flexibility refers to the ability to understand multiple alternatives. And a person with a lack of mental flexibility often cannot perceive that there could be multiple alternatives. They also have difficulty comprehending change. Mental flexibility is different from simple stubbornness. For example, the stubborn person can usually articulate reasons why that the person is not accepting alternate perspectives, whereas the person who lacks mental flexibility is not able to understand that there are different perspectives. Calculation problems. I don't think that's a good sign for lawyers because we're not really very good at math in general, but calculation problems can be an example of diminished capacity. Disorientation is just not being oriented to time or place or date. There can be emotional signs that indicate diminished capacity. Significant emotional distress beyond what is expected in the circumstances. So if someone is extremely anxious or tearful, such that their emotional state makes it difficult to address the relevant question. Emotional lability goes to displaying an extremely wide range of emotions, maybe moving from laughter to tears very quickly, or from laughter to tears to laughter again, or exhibiting emotions that aren't really expected in the context of what's being discussed. For example, laughing when talking about the death of a child. Possible behavioral signs of diminished capacity include poor grooming or hygiene, delusions, and hallucinations. Now, delusions are beliefs that are unlikely to be true, such as a belief that your neighbors or the government are spying on you. And the presence of delusions calls into question the extent to which decisions are founded on sound reasoning. Hallucinations are sensory experiences in the absence of physical stimuli that could be responsible for the experience. So, for example, if a person who's recently widowed hears the voice of her deceased spouse talking to her, there's no physical stimuli that would explain the spouse speaking to her. That's an auditory hallucination. So just because we have these red flags doesn't mean that the person cannot participate in the mediation per se. There are mitigating factors that could explain the symptoms and not be diminished capacity. For example, stress, grief, depression, reversible medical factors, hearing and vision loss, and education. If a party is experiencing stress, grief, or depression, the symptoms of those conditions can mimic diminished capacity. A person who's grieving can have problems with comprehension and may need things repeated and ask the same questions. A person with depression can be slow on the uptake. Reversible medical factors are really important considerations when you're looking at diminished capacity. For example, an undetected urinary tract infection can cause delusions and hallucinations. An accommodation in that situation is to reschedule for a time after the infection is cleared up. Likewise, dehydration or electrolyte imbalance can result in the symptoms of diminished capacity. And again, you want to reschedule until the medical condition is cleared up. Hearing and vision loss are also reasons for mitigating factors for diminished capacity. If you can't hear, you can't respond appropriately and may appear to have diminished capacity. Or you may be subject to sensory misperception with severe hearing loss or severe vision loss. Once we've recognized that we're dealing with a person with incapacity or with diminished capacity, what steps does the mediator take? And I'll turn it over to Tony now for that.
Okay. So if you know the Mediator Code of Ethics, one of the things that they're very, very clear about is that we need to be mindful that we're dealing with the parties to the mediation. You know, most of the time or often, the parties are represented by their attorneys, and that's great and certainly welcome, but the mediator's responsibility is to the parties. So we have to make sure that they understand what's going on and that they understand what they're agreeing to. It is not unusual to have an attorney say, oh, I'll just explain it to her later. This is a good deal, let's sign. And we can't do that. We're not technically supposed to do that. We need to make sure that the party themselves understand what's going on. That's part of the code of ethics. Next slide. So it comes down to being able to determine their self-interest, what they want. When we first start the process of a mediation, we talk to generally both sides, and often they're very clear about what has gone wrong. They're not entirely clear about what they want. And so it's often not until we're in the midst of the mediation that they decide what it is they want. So they have to be able to say what they want. And then they have to be able to own the process, because we know that nobody gets all that they want. There has to be compromises. So the parties both need, or each need, to understand what it is that they're agreeing to and agree to it wholeheartedly. Understand that they've made a compromise and that this is going to be the process and it's binding. So we have to make sure that those two things are in place: self-interest and self-determination. So next slide. How do you know when someone has capacity? Well, obviously we don't always. If during the mediation we see that someone does not have the ability, doesn't seem to have the ability for either self-interest or self-determination, we need to stop. Sometimes the stop is just to take a break and take a step back and figure out if there's something we can do. And sometimes it's a reschedule, and sometimes it's just a termination. So how do we know which? Well, we need to bear in mind that regardless of whether or not a mediation participant has a disability or has people's capacity to participate varies, we need to make sure that whatever disabling condition they have, that we can, if possible, address it and accommodate it, so that each party feels like they're a part of the process and is an active part of the process. So go ahead, next slide. So we want to look for these kinds of things. We want to consider these things. Is the party receiving the information? If not, why not? There may be a hearing impairment. Often there's a language difference. Sometimes there's fear, especially when we're dealing with parties that have been in an abusive relationship. There's a level of fear. The person that's been abused doesn't really want to say what they want for fear of reprisals. And so, we have to accommodate that. Sometimes putting them in separate rooms. Zoom has been helpful in those situations. Probably one of the times that Zoom is a preference as opposed to face-to-face. But we can accommodate those things. They may have diminished capacity, but there's things that we can do. If there's a hearing impairment, then we can speak louder and slower. If there's a language difference, we can have interpreters come in. There's so many things that we can do to accommodate. Then the next question is the party processing information in a way that seems rational and replicable? This is a little bit more tricky to decipher, I think. So I often say to a person, let me say back what I think I'm hearing, so that we can have that conversation, so she can or he can clarify what it is they're trying to say, what it is they're trying to articulate as to what they want or what they're willing to compromise. Often things like writing things down is helpful too. If I'm writing things down as they're talking, but if they are writing things down too, it helps them take a look and see, is this rational? Is this what I'm saying rational? And can it be replicated? Can they communicate the results? This kind of goes back to some of the cognitive signs that Carol mentioned earlier, especially lack of mental flexibility. If you can't see that there are possibly results, other options, then it's really, really hard to mediate. If you're refusing to change, or you can't see that the change, you can't even fathom that it's a possibility, then it's difficult to move on. But sometimes if you break the information down into bite-sized chunks, they're more able to grasp different kinds of concepts, and we can continue to move on. It may mean that we have to extend what we thought was going to be a half-day mediation into a full-day mediation, but the goal is to get the settlement agreement, to get it mediated and get it agreed upon so that they can be finished with the issue. Because we know that when two or more parties are coming into a mediation, there's already aggravation. There's already, often, because we deal with the elderly, the crux of our mediation is with families who are splitting up over someone's death or someone's sickness. And so there's a lot of anger, there's a lot of things that they want to vent, that they're not really sure how they want this to turn out, but they just want to say what they want to say. And so we have to make sure that they have the opportunity to communicate in a kind way, but that they then also can get to the place where they can agree to a plan and improvise it, that they need to be able to implement it into practice. So those are the things that we consider when we're talking with our people. So the next slide. So as I talked about earlier, how can we kind of accommodate someone with diminished capacity? Slow down. You know, we live in a world that is crazy fast. And so our tendency is to get everything done quickly, but we need to just maybe slow down and really watch the parties. I prefer having face-to-face meetings, because it's not just about what people say, it's their body language. It's, you know, what are they doing with their hands? Where are they looking? One of the downsides of doing Zoom mediations is that you don't know if other people are in the room. You really can't tell if the screen's not that way, and you don't know what they're doing on their phone. So I prefer to have face-to-face so that I can really watch what's going on and how, you know, how they're holding themselves. And if I see that there's someone that's struggling, we can take a moment and see if there's a way to accommodate whatever's going on. It may be that there is a hearing impairment and we need to speak louder, but there may be a language, as we mentioned before, problem. So then we need to stop, reschedule, and get an interpreter in. Hold frequent private caucuses. Take people aside. You know, the last thing we want to do in a group setting is to embarrass any of the parties. So we want to take a caucus and take them aside and say, okay, is there anything I can do to help you understand what we've just talked about and where it's headed? So we want to hold as many private chats as we need to help accommodate. Sometimes they need a third-party support person in there, especially if they're, you know, anytime you're doing anything that has the persona of legal, there's always a little bit of nervousness. And so when you're dealing with someone that's struggling in diminished capacity, they need sometimes a support person. And so allow them in. If everybody's agreeable, then allow them in so that we can get what we are there for accomplished. So the next slide. So again, we want to recap regularly. We don't want to wait till the end and say, okay, this is what we've agreed to and hope everybody's on board. You know, we want to go slow. We want to recap. We want to take our time. If we need to clarify things, then we need to step back. we need to make sure as mediators, one of the things that's really important is to make sure that there's respect in the room, which is sometimes hard because we're dealing with families, and families tend to know each other so well that respect kind of goes out the window. So you really have to make sure that stays in the room so people have a sense that they can say what they need to say without any kind of any blowback. We want to regularly verify the party's understanding, have them say it back or maybe read it back if they've written it down, which is always a preference. For me, I learn best if I write things down. That's how it sticks with me. So, I can't assume that everybody learns that way, but I know that often if it's written, it's easier for them to go back to and talk about. And then we want to provide each party with effective notes from the meeting, more than just the settlement agreement. We want to be able to really go through what we discussed and what we're coming to. It does take a lot longer to do it with this, particularly with the population that we serve. It takes a lot longer to get through, but I think at the end, they're more satisfied with the outcome. So go ahead and go to the next slide. Okay. In 1999, there was this study done with Roth, Meisel, and Lids. I think it's in the UK, but it was 1977 was when it's done. And it was based on the idea of informed consent as to medical decision-making, specifically to psychiatry, but the kind of the formulation that they brought into the table has kind of been the standard. So there's been a lot more studies done since 1977, obviously, but this has always kind of remained the baseline, and it's kind of been the adopted mode for most mediation. We want to look and see if each party is showing choice. Back to, self-interest. Are they able to say, this is what I want? And is that choice reasonable considering, where we're at, what we talked about? Then is that based on rational reasons? Sometimes people come in and I did a mediation when I was in training with a young lady who had, her boyfriend had broken up with a text, and they had accumulated a lot of stuff together, and they ended up, she wanted her stuff back, and it got into this mess. And at the end of the day, through a while of mediation, all she really wanted was an apology for the way he broke up with her. That was all she really wanted. After we figured that out and got that, she agreed to whatever. That wasn't, so you have to kind of get down into the nitty gritty. Is it a rational reason? Well, not entirely, but is it what she wanted? Yeah. And if once she got there, did she understand it? Yeah. So was there ability to understand and actual understanding, which sometimes can be different. Sometimes we say things and we think the connotation is coming through, but sometimes what we say is not what people hear. So we need to be careful to make sure that what they understand is what actually is happening. Okay, the next slide. So all of this sort of has to be done on the fly. We're checking out how people are presenting themselves. We're checking out how they're sitting, where they're looking. Are they taking notes? Are they engaged? Are they looking out the window? Watching. In our office, you can watch the planes take off. So are they really participating? And we have to be visually note-taking to make sure that everybody is getting what they need, not just the agreement, but understanding what the agreement means and what it means to them in the future. And if we need to stop, if we're seeing something going wrong, we need to address it. And at that moment, one of the things that one of the mistakes I made in one of my very first practices was that I took notes about the things that I thought were wrong and then tried to address them later. And that doesn't work. We need to do it right while things are happening. You know, if we see somebody kind of shrinking back into their seat, we need to address that, you know, call a private caucus and ask them why. And so we need to be visually aware of the parties and what's going on with them. And then the next slide. If it does appear that someone does not have capacity, we have to stop. We have to stop because we don't want later them to be able to say, I didn't know what I was doing. We want everybody to be on board. That's the whole point of mediation, is to avoid having to go and litigate issues. So we want to make sure that everybody is clear and clearly agreeable to what we've decided. And if we can see that that's not happening, we need to stop. That doesn't mean we have to terminate the whole mediation necessarily, but we may need to reschedule. We may need to take a break. Whatever it is, we need to stop until we can address the issue. And if it turns out that we cannot address it, that it can't be fixed, then we need to just terminate the entire process. So the next one, I think there's one more. Is there? So we have to be careful not to confuse capacity with a physical disability. You know, again, back to the hearing, or even maybe seeing, or, you know, not being able to communicate well. We can't confuse that disability with not having capacity. It's diminished, but it's not insurmountable. We can't confuse bad faith. Most of the mediators that I talk to that do court required mediation, they sometimes struggle a little bit because the people are coming because the court told them to, not because they want to resolve anything. They just have to get through this step to get back to court. And so that's a bad faith attitude, but it isn't an incapacity issue. It's just a bad faith or just an attitude problem. You know, maybe someone's been kind of always the controller in the family or the controller of the group, and they come in and they expect to be in control, and when they figure out they're not, then, you know, they catch attitude. So you have to be mindful that that's not a capacity issue. That's just a bad attitude, and work with that. You know, call a caucus. If it looks like we're at a standstill and they're not going to be able to actively participate, terminate, but not because of capacity, just because they got a bad attitude. All right, I think that's it. Are there any questions or comments?
Well, let's see here. Thank you very much, first of all, Tony and Carol. I do see one on the chat from Mr. Reed, Rick Reed. The question here is, should the mediator make it clear that a decision to involve a support person for a party with diminished capacity is part of the confidential mediation process and therefore not something that will be used against that party in the future?
Yes, anybody in the room needs to understand that what happens in the mediation is entirely confidential, and that if they're there in the room, then they have a strict confidentiality. They have to adhere to it. I heard this was a little scary. I was at a HOA meeting, as you can imagine how fun that was. And there was a mediation going on. Someone on our board of directors is actually suing the condominium association, and the mediator called the whole board in on the mediation, and they did it via Zoom. And the spouses of those board members heard the entire mediation, but did not agree to any confidentiality. And so, you know, what do you do in those circumstances? Well, you know, technically, fortunately, they didn't agree to anything and it just kind of terminated, but that could have been a really bad situation. So be mindful if you're doing things like Zoom, that they are in a closed room and whoever is in the house is not near them.
Okay. All right. We have a couple more questions here. Let me get to this one first. This is from Danielle Hargrove, who asks, do mediators typically waive their fees off when a mediation has to be terminated for incapacity issues?
We charge an admin fee, or at least our office does. We charge an admin fee, but if it's clear that we are not going to get anywhere, we generally don't charge for the whole thing.
Okay, that's by example. And then another question here, could you please give us an example of how you would inform the parties, or how you recommend that we inform the parties that the mediation is being terminated due to an issue of diminished capacity?
Well, and that's tricky because you don't want to embarrass anybody.
Right.
But typically, the rule of thumb is to take everybody out in private caucus and just say, we can't finish this. We're not going to be able to finish, and just leave it at that. As mediators, we don't have to give a reason for termination. We generally do because it's courteous, but we are not really required to. We can just say we need to terminate and leave it at that. But I do it privately because we don't, especially in family dynamics. There's already so much going on. And if we say this person can't continue because they don't have capacity, that's just like a loaded gun that we're handing somebody. So we don't want to do that.
Would you think it'd be the same in a situation where you sense, but don't have any specific knowledge, that one of the representatives, an attorney for one of the parties whom which you suspect has diminished capacity, that attorney doesn't quite see it? In a situation where the attorney seems to be maybe exercising some real power over the person with suspected diminished capacity. Any recommendations, thoughts on how to handle that?
I just was at a conference and we did a whole panel conversation on some of this. One of the things that's been hard as a mediator in a law office is when people call, they expect to be represented. So it's really difficult to clarify that I don't represent anyone. I'm just a facilitator. And I think sometimes attorneys are so zealous in their representation that they kind of step over the line a little bit. And so while we can't, it's probably prudent to take the attorney aside, to just call a break, a bathroom break or whatever it is, and take and have a private conversation with the attorney and say, I'm bound by the code of ethics to make sure the party understands. I know you get it because you're an attorney and you're smart and you've got this handled, but I need to make sure your client gets it. And so you need to let them speak. And, I think for the most part, they're fine with that. I think mostly they're fine. There's always going to be one that isn't, but mostly I think they're fine with that.
Okay. Now I know this, I kind of suspect I might know the answer to this, but when you craft your mediated settlement agreement and you have, of course, the language that goes into an MSA, and you believe there may be an issue of diminished capacity, what do you think about including a provision in there, the parties on a stand? I mean, is there any magic language that a mediator should or could use, or you recommend that be used to address that issue to protect the mediator in that situation?
That's a really good point. And actually, I was thinking about this weekend when I was going over this, and I was thinking, wow, we probably need to have something in the settlement agreement that says, we're certifying that everybody that signs this knows what they're signing, or some kind of protective language. But at the end of the day, I think it's not often that you can't spot the problem. I'm sure there are times when you can't, when it just gets right by you. But I think most of the time you can spot the problem, and the best solution is to just terminate. Then, if they need to go back to court, let the judge decide, because we want to be sure that everybody is on board and owns what they just signed.
Exactly. Okay. Someone asked earlier if we can perhaps maybe get a copy of your slides.
Sure.
If you wish to put copyright on there or something, you're more than welcome to do that. But we would certainly appreciate that. Let me ask another question. I think is kind of related to this. We're seeing obviously a lot of cases coming up in our probate courts. As many people know, probate courts have kind of doubled their staff almost, not just with associate judges, but also with court staff as well. So we're seeing a big influx of that. The courts typically, as far as I know, in the local rules, I don't think there's a specific requirement under the probate court's local rules that cases be referred to mediation prior to a trial, although it could be wrong. They may have been updated. If mediators are interested in handling some of those cases of diminished capacity or probate related cases, what can they do in that situation? Do you suggest they contact the court staff, or how do the mediators here in San Antonio try to help the court alleviate those cases and take them off the docket through mediation?
I think for the most part, the probate courts, if there's a contested matter, I think for the most part they kind of hand it over to the dispute resolution center. So I'm not exactly sure, to be honest, how to get on their wheel so that they would send them to us. The thing about our particular practice, though, is that we don't, we don't deal with a lot of litigation as a practice. As Carol's practice, we don't do litigation. So we are not known for that. So I think it would be harder for us to break into that, but we deal with parties in dispute daily because something's happened to mom or dad. Mm-hmm. And so that's really kind of where our niche is.
Sure. Great.
But I would think if you caught hold of Marty or any of the court staff and said you were interested, I would think that they would take that into consideration.
That would be Marty Collins, the court attorney for, I believe, for probate court number 1, right?
1, yeah.
Yeah. Okay. And then I have some of these questions are kind of my own. I'm sort of coming up with some of them, but if anyone else has a question they want to put in the chat, feel free to do that. I surmise that with the increase in the number of probate cases overall, you're seeing a lot more cases of diminished capacity here in the county and perhaps statewide. Can you talk about that? What are you all seeing in terms of the influx of new cases with people in the elder law?
Carol, you want to address that?
Sure. I'd say that is the truth. We are seeing more and more people with diminished capacity, with dementia diagnoses, needing guardianship. In fact, there seems to be so much of an influx of folks who need guardianship that it's hard to find folks who'll represent them. There's just so many.
And do those cases routinely get addressed in mediation as well? Because we're not just in disputed matters, but just in other matters as well, like just a typical guardianship or probate where someone is involved in diminished capacity.
Well, the influx I was referring to was actually uncontested guardianships, where the proposed ward is pretty obviously incapacitated and needs some assistance. Mm-hmm. But of course, there's always families that are fighting over who should render the assistance. So yes, those would be appropriate for mediation for sure.
I see. Okay. Or is anything else you want to add about perhaps any other issues in mediation that you feel should be discussed or that mediators should know? Maybe there's a reference or sources of information that the mediator who handles or is looking, excuse me, to handle such cases, maybe a resource they can look to, read?
The ABA has a lawyer's guide not specific to mediators, of course, a lawyer's guide to, let me get the exact title, Assessment of Older Adults with Diminished Capacity. And that's an excellent resource for working with folks with diminished capacity from the ABA.
I'm going to put it in the chat. Would you mind stating that again? I'm sorry, Carol.
Sure, let me put it in.
Oh, okay, great. Just select everyone if you can on there.
Sure.
It's always good to have a handy reference specifically for mediation in this particular context.
I think joining, as you know, joining groups of other mediators, because many mediators are not attorneys. And so I think joining groups and getting some input from people who are non-attorneys and attorneys about how they're dealing, because the lack of capacity will affect every area, family law, the whole thing. And so how are they dealing with it, and what tricks of the trade do they have to make sure, the community is always stronger when you are working together.
Sure. And I see Al Cortez on the list of participants or attendees. And of course, he's with the Bexar County Dispute Resolution Center, and I'm sure they see a lot of these cases too.
Yeah.
Okay, great. Well, if there aren't any other questions, we are certainly thankful for your taking time out of your schedule to join us. As you can see, Carol has posted the Assessment of Older Adults with Diminished Capacity Handbook for Lawyers. This is from the ABA, so I'm sure you can Google that. There's the course number, the CLE course number. This is, I believe, 1 hour of CLE, and you can self-report it. We have a couple of questions. One more, let's see. What age range are we seeing these cases showing themselves? What are the age ranges?
Unfortunately, incapacity or diminished capacity can strike just about any age. Of course, you could always have someone with a traumatic brain injury and diminished capacity that way, but early onset dementia can strike folks, or frontotemporal lobe dementia can strike folks in their 50s. So we can see
50s.
Yeah.
Would you mind, I forgot to just kind of remind everyone, if you are able to make the slides available, Carol, is your email, would you feel be okay with putting yours and Tony's email there in the chat?
Sure.
And do that. I'm going to put, there it is, cbirch@assistingseniors.com. I'm also going to add, I mentioned at the top of the program, the programming that the ABA is making available for all of us as members of the San Antonio Bar in the ADR section. We get a really, really great discount from the ABA on upcoming dispute resolution programming. And this is for the upcoming spring conference that's virtual, and the Arbitration Institute, Training Institute that's coming up in June. For those of you aspiring to be arbitrators, or even if your experience as an arbitrator, that is probably the best program you will see during the year, or one of the best, let's put it that way. So that's in there. Al Cortez has posted something. So the rules of mediation adopted by the civil courts, I guess this is part of the rules, local rules, provide great information concerning the protection for mediators. So that's something to visit as well. And we thank you all very much once again
Thank
for
you.
joining us. And yes, thank you, Carol. Nice seeing you. Kind of so you're looking great. Tony, nice meeting you.
Nice meeting you too. Thank you.
And I will vouch for everyone. I've called Carol on a few occasions when I've had a hiccup on a case, or we just needed to find out, just kind of what she thought. And she is a tremendously great resource, and knows her way around all of the different issues that come up with elder law. As many, we know there are many issues that do come up. So consider Carol a friend of yours, and we hope this has been helpful to you all. Thank you all very much, and stay safe and goodwill to everyone.